Lord, before your Lordship, paragraph legal view of the matter, at the cost of repetition. Lord, we had an option of challenging this order and seeking stay of the order. But considering the position on ground, Lord, there is one tribe which is, according to the High Court, should be conferred with the status. Lord, we chose not to, my Lord, seek stay and seek only extension for 1 year, so that situation calms down.
Paragraph 15, placitum F.
Because stay would have some impact, not again on the situation on the ground.
Paragraph F. Courts cannot and should not expand jurisdiction to deal with the question as to whether a particular caste, subcaste, a group, part of tribe, subtribe is included in any one of the entries mentioned in the presidential order issued under Article 341 and 342. Particularly so when in clause 2 of the said article, it is expressly stated that the said orders cannot be amended or varied except by law made by Parliament. The power to include, exclude, amend, or alter the presidential order is expressly and exclusively conferred on and vested with Parliament, and that too by making a law. Then, my Lord, a little bit on the next page. Allowing the state governments or courts or any other authority or tribunal to hold inquiry as to whether a particular caste or tribe should be considered as one included in the schedule of the presidential order when it is not so specifically included may lead to problems. A little lower than that, my Lord. That apart, when no other authority other than Parliament, that too by law alone, can amend the presidential order, neither the state governments nor the courts, nor tribunal, nor any authority can assume clear, the first respondent state is directed to submit the recommendation.
Are you appearing before the DB?
Yes.
No, my Lord, I
It's
can't.
the same party.
No.
It's the same party which has filed
It's not the same party, sir.
the original petitioner here.
I'll tell you, Lordship,
Page 9 of my
tell you, Lordship, one.
Chief
Is different. Should be the order of the.
Mr. Gonsalves.
Yes, sir.
Now that an appeal has been filed before the division bench.
Yes.
Which is writ appeal 88 of 2023 by the All Manipur Tribal Union.
Yes.
You can join in that appeal. You can.
No, I'll tell you, Lordship, what's happened. We can't go to the High Court. The cookies can't go. We had to ask somebody else to represent us.
I'm sorry.
In the High Court, no cookie lawyer is appearing and can appear, because, just a minute, please. Because the area of the High
Don't
Court
say that.
is 1 kilometer from the villages that have been burnt down.
Let's not.
So no cookie lawyer is appearing in the High Court at all. It's not possible. It's a very dangerous situation for a cookie lawyer to go
The
there.
order itself has been stayed for a year now.
Anyone can appear on the video conferencing platform. What is the difficulty?
The internet is also intermittently working, my lord. It's very
Tell
dangerous
the-
to go
You
there.
can ask the Chief Justice to, yes, let the High Court, you file a writ appeal again. A writ appeal has now been entertained.
It's not by me, my lord. It's by another
No, but
organization.
a writ
Yes.
appeal has been entertained.
And they went,
You can seek a stay of the order.
they went, my lord, for impleadment. The
There was
tribal
writ appeal,
union
you
went
would
for
have taken a
impleadment.
different view, but there is a writ appeal now with the High Court.
Already
It's
tribal union has filed the writ
The
appeal.
All Manipur Tribal Union has already filed a writ appeal against the order of the single judge, which will be considered on the 6th of June. It's coming up now.
Yes, my lord, but we are not, it's not possible for the cookies to go there at all. Neither the victims can go nor the lawyers can.
Lord, that is factually
And not
incorrect.
the single
Lord, if
one, you see
somebody
the
wants to
appearances,
go, we will
the
provide
single one is
Lord, but Lord, such arguments, Lord.
So when the attack
Aggravated
place,
All right, that is one aspect on the correctness of the order. Now we have seen that a writ appeal has been filed and that 1 year's time has been granted by the.
On our request.
no, that's for what? Let me clarify that. That's not on the order directing the state to send the recommendation.
It's time for consideration of the direction made at direction 3 of the order is extended for a period of 1 year from the. date of
Correct.
the order.
That is that the state should consider the representations made by the
It has been given a
tribals.
year's time, but this will not affect anyway the correctness of the original order because the writ appeal has been filed against.
Yes, my lord, that can always be examined, my lord. And therefore, my lord, possibly the appellant whom he represented has sought to withdraw.
Yes.
He understood the problem that.
No. Now see what they did to him.
Now insofar as the rehabilitation is concerned,
Yes.
Can I show you that, my lord?
yes.
Can I show you that? Turn to my
Now, I've seen this part
application
of the
for directions,
Tell us, Minister.
which are urgently needed. Turn to that, my lord. Turn to my application for
But
directions.
this will keep on coming.
See what I
Actually,
urgently-
they are correct. I have taken instructions. They are, Lord, I stopped, Lord, at that.
Now see what I need.
Let's leave that apart right now.
No, I don't
Let
want to
us-
leave. The matter was pending. I want protection from the army to the areas that will be attacked soon, our anticipation. Now, what has happened? Army was there right from the beginning, third. Army was always in Imphal. Chief Minister did not allow them to come out. Chief Minister told them, you stay, when I want you, I'll call you out.
I don't want.
Third onwards, seventh, now wait a minute, please. Third onwards,
Switch
third
out.
onwards,
Camps.
just a minute.
No chief minister gained
Third onwards,
permitting the situation to flare up. Lord. It's
and
a-
that's exactly.
It's
So now
politically,
when
Lord.
asking,
All right.
can I just speak, my lord?
not fair,
Can I
say-
just argue? I want to argue and give my
1 second. 1 second. 1 second.
army protection. we
1
want.
second.
Yes.
1 second. A status report has been filed on behalf of the state of Manipur, indicating, bracket 1, the steps taken to bring normalcy to the law and order situation in the state, comma. Bracket 2, details of release camps which have been opened, semicolon. Compensation packages made available on account of death or as the case may be injury. Bracket 4. Security measures for protecting religious places. Semicolon. 5. Transportation of persons who are stranded due to the ongoing crisis. Semicolon. And bracket 5. Registration of FIRs. And the recovery of arms. Good stuff. Besides the above aspects, Oma, the status report is also, the state of Manipur has adverted to two developments which have taken place before the High Court. Colon. Bracket 1, the writ appeal has been, the writ appeal, MC bracket WA number 88 of 2023 has been filed by the All Manipur Tribal Union and others against the judgment of Justice M.B. Muralidharan against the judgment dated, dated 27 March 2023 of a single judge of the High Court of Manipur, into brackets, Justice A.V. Muralidharan, M.B. Muralidharan. Full stop. While entertaining the writ appeal has been entertained by a division bench of the High Court on 15 May 2023, and while issuing notice, the case has been directed, the writ appeal has been directed to be listed on 6 June 2023. Semicolon, bracket 2. An application was moved by the state of Manipur before the single judge who passed the order dated 27 March 2023 for extension of time, for considering for extension of time on which the single judge has directed that time for considering the direction, the time for considering direction bracket 3 in the order dated 27 March 2023 shall stand extended by a period of 1 year. Stop. The Mr. Tushar Mehta, the next Solicitor General, states that having due regard to the sensitive law and order situation which had emerged in the state, the state government at this stage had moved the single judge for extension of time, a period of 1 year, so that the situation can normalize in the meantime.
Can I show your lordship what I'm...
Stop, 1 second, let me stop. Next, since the division bench of the High Court of Mr. Faluk Gonsalves, then senior counsel appearing on behalf of the
Petitioners.
The petitioners, which admits that the direction which was issued by the single judge in the order dated 27 March 2023 is contrary to the settled position of law, which has been expounded by a constitutional bench of this court in state of Maharashtra versus Millen, 2001, 1 SEC, page 4. Since the writ appeal is pending before the division bench, we leave it open.
Can I show you, my lord, what I need, please?
We leave it open to the...
I want to point out before your lordship finishes the order.
Parties who are aggrieved by the order of the single judge to make appropriate submissions before the division bench in that regard. Full stop. Next. Full stop. It is any party aggrieved by an order passed by the division bench of the writ appeal would be at liberty to pursue its rights and remedies before this court.
Can I show your lordship, my lord, what I'm asking urgently today? Today, before anything goes.
Yeah.
Page 18.
You must clarify.
Page 18.
He appears for. Mr. Gangman.
Page 18.
Why don't
For
you...
the petition.
1 second.
Page 18. This is the areas.
Why don't you identify what you're
I've identified the areas where the tribals fear imminent attack. My whole application shows from 3rd onwards, 70% skilled. I'm not going into that.
Why don't you tell us what specifically you want in the nature of...
Yes, prayer clause A and B.
Alternatively,
Prayer clause A and B.
but it is not possible.
At page-
Mr.
At page
Salvis
23.
knows and police doesn't know. Let
Page
me bring it to
23.
the notice of
Let us see Mr. Gonsalves's IA. Have you, sir, is that
Yes.
e-file or not?
No, yes, E-file 103548 and served on the other side 2 days ago.
If there is any apprehension by.
Yes, there is, sir. 3. I limit it to
May I
that, forget
suggest-
everything else.
May I suggest?
No, you
Not
listen to
Mr.
me
Gonsalves.
first. Page 23.
Anyone,
Now see
my lord,
prayer clause
any
A.
apprehension,
Mr. Solicitor, we have something in mind. Let's just, we only see, yours is in 17.2, right? Yeah.
Prayer clause A is at page 23.
10
listed the villages at page 18,
Yes.
where the attacks are likely to happen. And at my prayer clause is at page A,
Don't create.
that the
panic
Indian
by
army is
villages
stationed
that are
there
likely
to protect these persons. Because the police are on the side of the assailants.
Lord, again at the.
Prayer clause A.
Interruption, it would
And
be
prayer clause
really
B.
irresponsible to say, it would create panic that these are the villages where attacks are likely to happen. Because one individual.
80 people killed, villages destroyed, even while the matter is pending in court. Army not called out. Army not called out, and the chief minister asked them to stand down. So I'm asking, let the army go to these villages.
Mr.
See
Gonzalez.
page 18.
Mr. Gonzalez.
Page 18 is the list.
1 second.
Yes.
Let us see what you have said. Then
Yes.
something in mind.
Yes.
Just want to identify what you have said in the application. Just
Yes.
That page.
Shall I show that? Yes, yes. Please see that, my lord. Turn to page 4. I'll just show you quickly within a few minutes.
Now we are at para 53, page 18, since you were saying page.
I took you to that page because I skipped over pages, but if you want to see what it says, let me show you in a few minutes. Turn to
One
page.
page you've already got it. Mr. Gonzalez, you already read it. Yes.
So I've got day by day the attacks and the killings. So the total stands at 70 today. Now, my lord, at page 18 is the list of the villages where the attacks are likely to take place. We've received information, the planning is taking place by two very militant armed organizations that I've stated here.
I'm sorry, my lord.
Under the protection of the chief
Throwing a
minister.
target there.
Yes.
And I have
Under the
received
This might
Now,
create a
please don't-
panic among
I have
the
come-
villagers.
Just 1 second.
Only
1
want to
second.
speak in
1
peace,
second.
that's all.
1 second.
Yes.
IA number, just 1 second, please.
Yes.
IA number क्या है ये?
I number 103548. It's listed today.
IA number
3548.
3548 of 2023. Certain apprehensions have been expressed on behalf of the petitioners. Based on the apprehensions, the petitioners have sought appropriate directions so that necessary steps can be taken for enhancing security measures in sensitive areas.
In the villages set out.
Sensitive areas. Certain specific villages have also been identified in the IA. Full stop. We have the considered view that we have the considered view that the apprehensions which are expressed in the IA will be taken to account by authorities who are interested with monitoring the law and order situation in the state. Full stop. A copy of the IA shall be forwarded to the Chief Secretary of the State of Manipur, together with the security advisor. You have said that the security advisor also took.
There is a security advisor who is former DG of CRPF,
And the
very
security advisor.
decorated officer.
Full stop. And the security advisor. Full stop. The competent authorities shall immediately attend to the grievance after due verification and take such appropriate measures as are required to foster confidence and ensure peace and tranquility.
Yes. Now, my lord, I understand. If you want me to go back to the High Court, I'll go back.
Also give it.
Will your lordship transfer this matter to the High Court? I'll go back immediately. I want protection for certain, which I can't tell your lordship today, but I, yes.
There is an item 33 also.
But I am on page 33, my lord.
33
Can I just finish, my lord?
is our apprehension. My lord, we have filed a PIL.
Yes.
We have pointed out, my lord, that certain parts of the state are now, my lord, out of control of, my lord, the administration also.
But that's
Because
what I
they
want
have
to
put up
take your notice.
barriers, they have put up barriers on the national highways and they have cut off the water channels. Now, so therefore, my lord, these apprehensions, my lord, have been, are the subject matter of 33.2, my lord.
Permit me 1 minute, my lord.
Full stop. Other IAs have been filed by.
No, my lord, I have filed a writ, my lord, the High Court Bar Association.
Yes.
Just half a minute. But the High Court Bar Association of Manipur has filed a writ petition number 574, which is listed as item 33 today and tagged on with item 17.
Right.
But I want to show to your lordship just 2 paragraphs, if your lordship permit me, at page 6 and 8.
Why don't you make the
What
point?
do they say?
The point is, my lord, that there are illegal immigrants coming in through a porous border of 398 kilometers from Myanmar. And they are the ones who are creating all this problem about whatever is happening in the state today. The second, and they want to settle down because of what is happening in Myanmar. They want to settle down and come and stay in Manipur. That's one. Secondly, my lord, they are very much into big poppy cultivation and drug trade. So what is happening is that when people are going and trying to get the poppy cultivation to be regulated or otherwise destroyed, it is thought to be destroyed. That is how these militant camps are arising out of Myanmar and making the hell for the people of Manipur.
I don't understand.
Therefore,
We are dying.
See, okay.
Only we are dying.
I have filed a writ.
We are dying.
Monopoly on.
I can't speak on Mr. Gonzalez.
This is a serious concern, my lord.
Therefore, because I am concerned.
Have a brief opportunity to give us their view.
Yes, so therefore, I'm only bringing that to you, not. I have specifically made this averment in para D and E of my writ petition 574 by the High Court of Association of Manipur. And this is the larger problem, which is the basis for this entire agitation that has happened. And the militant camps are coming out of Myanmar.
By appearing
If
33.
your lordship is thinking.
Just
Only one.
Similar writ petitions and
Just that we
applications,
can't do anything.
similar
We'll
writ
ask
petitions
authorities.
and applications have been filed before this court by other parties.
576, 574.
Mine is 574, my lord.
One submission on one IA.
All right. Similar writ petitions and applications have been filed by other parties before this court. Full stop. This includes a writ petition which was instituted by the High Court Bar Association of Manipur.
Manipur.
And my lord, the global weightage.
Now, my lord, my request is, please transfer these.
The content, the apprehensions, which have been, set up in the above petitions, or as the case may be applications, shall also be taken
Now, my lord, my request is,
taken into account by the, in similar terms, by the law enforcement authorities as directed above.
my request is,
And
we'll all go to the
Liberty-
High
if
Court.
your lordships are not
Transfer
entertaining-
all the matters
If
to
your
the.
lordships are not entertaining, then I can go to the,
We'll all
I
transfer
can go
these
to the
matters.
division bench.
We'll
the
like
High
to see
Court.
this, what we'll do in this matter is.
Transfer all.
that- No, we are not transferring all proceedings to the High Court. Let the government of Manipur give us a fresh status report immediately after the reopening. We want some,
Yes, please, Lord.
to be apprised of what steps.
Yes, Lord, especially my
This is what-
petition, Lord, about.
this is- I have a- yeah.
We are not stalling any proceedings before the High Court, but independently as a constitutional court, we want to be apprised periodically on what steps are being taken.
We shall.
I have an IA. Lordship, attention, please.
First title.
There is 2 aspects. Just want to highlight 2 aspects. Item IA number 104041.
Yes.
Only 2 aspects.
Yes.
2 minutes. Lordship.
Yes.
Lordship, may kindly see page number 46.
No, you tell us. Yes. Nobody has.
Yeah, basically there is a suspension of operation against with the cookie militants or the so-called militants. So what is happening is that there is a complete breach of that arrangement, and the militants are coming out of their jungle camps and disturbing peace and tranquility. So that's one aspect which the government of India and the government of Manipur has to take care to ensure there's such operation, suspension of
Now look, I'll tell
operation.
you one
operation
thing,
is,
just one thing, one thing.
sorry, yeah.
Course of proceedings indicates that there are allegations which are being leveled by both sides here,
Yes.
right? We have now, therefore, we can't go and ascertain the correctness of allegations leveled by either side against the other. At the same time, we have serious pleadings on the record which indicate a need for intervention. That intervention by its very nature cannot be of a judicial body. that intervention has to be of
I understand.
administrative
The
cost,
general direction will do.
which is what we have done.
Yes.
We have flagged those concerns.
Yes.
We have said, we have referred to the repetitions, we have referred to the IAs, and we have said they have been filed by both sides, by different parties before this court. We have directed in our order that the chief secretary and the security advisor, who is a DGP rank officer, shall take into account these concerns and take necessary steps to ensure that peace and tranquility is maintained. So, and we have not just therefore left it.
Just report.
We are keeping this matter thereafter, filing a status report before us.
So
We are not, one second, we are not entering into the fray as to who primarily was responsible.
Yes, Your Lordship.
Because on the basis of just pleadings of one side bereft of any responses, it's very difficult for the court to do that. And doing that at this stage may not be advisable in the interest of
The
maintaining.
general direction, Lordship, to ensure that such arrangement is enforced. Because it's an agreement in place.
What we have said that.
Yeah. Another aspect,
Lordship, I appear 33 point.
Let me just continue. Another aspect, Lordship, I was flagging before the same bench in some other matter that the importance of national highways. There is a blockage of national highway at Kankura.
All this falls under the realm of law and order situation.
So
We have noted, we have asked.
It's a big stop for coming
authorities
people.
to look into the matter. There is nothing, we can't do anything more than that. We have indicated, we are keeping this matter
Law
pending.
and order is a state subject.
Yes, Lord.
We as the apex court can ensure that that the powers which are entrusted to the authorities are exercised by them.
Yes, Lordship.
That they don't turn a blind eye.
Yes, Lordship.
How to intervene, the manner in which intervention should be arrived at is a matter also of.
And also a line.
Arey bhai, suno to kabhi.
Understand this, Lordship.
Is a matter for the political arm of the executive. We must also as a court be conscious of the fact that certain matters are entrusted to the political arm of the
Yes, Lord.
government. We are here to prod them. We are here to ensure that there is no inaction by the state, which is what we intend to do. And we have kept the matter. We have not really accepted Mr. Gonsalves' submission that transfer everything to the High Court.
Understood, Lordship.
Because we don't want another round of highly politicized proceedings before the High Court. We want to retain control of it.
I'm happy with that.
One line on national highways.
Lordship, I appear in 33.
All apprehensions or facts, whatever, are to be taken care of.
Yeah, including national highways.
Lordship, I appear in 33.1. I appear in 33.1, Lordship. There are some very specific prayers that we have asked for and certain things that I wish to bring to my Lord's attention, which may kind of throw light on what Mr. Ranjit Kumar is saying, what Mr. Gonsalves is saying, and what is coming from the other side here. There. Lordship, I have my IA in 33.1, which is one.
Tell us. Don't-
Lordship, a prayer that we have asked for is that in pursuit of Lordship's directions in Kaushal Kishore, officials of the state machinery may be restrained in the statements they make in the public. Lordship, I have extracted posts and public statements made by the current chief,
Not get into all that.
which are openly communal,
Statements.
talking about how the cookies are foreigners, which is this whole foreigner business. The moment there's a conflict, one side is labeled as a foreigner. The chief minister is saying that this unrest in the state is being caused by cookie foreigners who have come into the state. Then and Lordship, I didn't wish to read it, but Lordship, you destroyed our Manipur in the name of Christianity, drugs, poppy, guns, lootings. This is something being fed by the chief minister from his official handle. Lordship, I have post after post of openly communal statements being made by him.
Copy, give me.
And Lordship,
Pasha, for the present, let us see
administration of
that
the
the
state-
law and order.
Mr. Solicitor, all that you would say is we're not writing this
All
in
of
our order, but some exercise of restraint.
Restraint, I am not, it
From
would be
every side,
conveyed.
From every side.
It would be conveyed, and so far as Mr. Pasha is
authority in the
concerned,
state.
And
so far as Mr. Pasha is concerned,
Lordship, in that
Mr. Ranjit Kumar's concern is right. So far as Mr. Pasha is
Pasha,
concerned,
one second, Mr. Pasha.
Mr. Ranjit Kumar's concern about Myanmar people entering illegally is right. And that is a concern of the government also, and steps are being taken.
Now, my lord, I want to request and ask.
Mr. Pasha expressed some apprehension.
Certainly, it would be
Advise-
conveyed in the spirit in which
Please advise the constitutional authorities that written statement should be made with a great sense of responsibility.
I bow.
Yes,
And
one
Lordship,
last.
at a
one
time
last
there is
request.
ongoing conflict, at that time, instead of resolving the conflict, to start making statements saying we'll take care of immigrant problem and
Pasha, you've made your point, and we have made our point.
One last request.
Now, separately
Just wait a minute. One last request. The villages that have been burned to the ground, state to begin reconstruction work so that people can go back to their homes. We
I
want
am
the state
sure
to
the
begin
state
that.
is more concerned than Mr. Gonsalves, I can assure you.
And that can happen after the militants return to their camps and surrender their weapons in accordance with the peace treaty.
Not understanding, sir.
Right now, that is the
Today we are homeless.
I think here we should.
We are only asked the state to
I think it is happening is
reconstruct these
the
villages.
fact that this is not just clearly a very legal proceeding in a court of law. We would not allow a forum to be dragged to any level apart from ventilating genuine legal grievances.
But geographically, what has happened, there are.
That's all we ask.
We will close this proceeding.
No
We do
further.
not want to get into areas of politics or policy.
Correct, sir.
We are very clear about what our remit as a constitutional court is.
But sir, reconstruction
Follow the next matter.
First week of July.
Yes, first week of July.
grateful.
Obliged, Lordship.
Lordship, if Lordship is directing that the High Court of Manipur take up that writ appeal, Lordship, I have an SLP which was mentioned on Monday, and Lordship, it's diary number 20891. Lordship may permit us, give us liberty to approach the High Court in writ appeal so that,
You can always find a writ appeal.
Lordship, we were not parties, we have moved an application.
Withdraw that.
Lordship,
You want to withdraw it?
Lordship, if Lordship is keeping it pending here, then
No, you want to withdraw
Take a
it.
choice.
You take a choice.
You want to go to
Lordship,
the High Court, you can go.
You go to the High Court.
Lordship, I understood that Lordship was directing, sending these matters back to the.
You're not-
Very well, Lordship. Lordship, just one prayer, nothing to do with any of this that we've asked for. Lordship, some compensation has been awarded and some claims, etc., are being filed. Lordship, because now the people who are victims, of, a lot of them are outside the state. Some are in Delhi, some are flown to Guwahati, etc. So, Lordship, applications for claims may be registered in the Manipur Bhavan in each of these states. And secondly, Lordship,
That depends upon, my lord, from where you have come. If you have come from Myanmar, there would be a different standard.
Lordship, this is the problem.
Sorry.
But Mr.
No, we'll take administrative call on it.
Not the grievance. Just look at it because
I will.
Generally, people who have been displaced from Dua.
Yes.
Actually, they should not be disabled from filing claims for
Yes.
And Lordship, because now they are also looking to file FIRs, they can't go back to file those FIRs. Lordship, so 0 FIRs may be registered in the jurisdictional police station where they are and may be remitted to the relevant police station of jurisdiction. That's a separate specific prayer I have in my
I
application.
will consider that as well.
Lordship, yes, IA 104680. Lordship, there is a specific.
Obliged.
I'm grateful, Lordship.
Support from all sides, my lord. Internet banking and all that has been affected. As soon as they can do something about it, that would be good. There are students from both sides who are not getting money here.
That also just check.
Internet is suspended.
Look at it. I'm grateful.
Grateful, Lordship.
My lords, in item number 18, this honorable court has directed the respondent state to decide my representation within 3 months. Was passed in
Why not?
Who's appearing for the state here? State of UP?
Lordship, office
My lord,
report
we have
is that he has
copy
not filed
the-
proof of the
additional
They have not
application.
filed proof of service, the office report indicates.
Yes, my lord, as per instructions, my lord, we have filed the, we have served the copy of
So
the.
where is the proof of service? Give a note. She's always here, Garima Prasad, somebody from the state of UP always comes when we ask them to appear in these premature release matters.
Serve a copy.
Serve a copy and come back.
My lord, may kindly fix a date in this matter.
On the reopening, yes.
My lord, there is one more thing. My lord, considering my age and the.
You comply with our order. Give a copy to them and come back.
Highly obliged.
Yes.
19.
We could do
Results
that.
are not signed. 19 to 28, letter it's in.
Who is appearing in this?
My lord, I am on a BC, my lord. Revati Rao.
You are appearing for the petitioner.
Yes, my lord.
Ma'am,
Petitioner number 2, my lord. Petitioner 1, I am not.
disposed of in 1996.
1996.
Yes, my lord.
Considering
My
there
lord,
are
I am under custody for the past 30 years, my lord.
sentenced to life. How can you file an MA in this in 2023 for early release? You follow your remedies in accordance with law.
Amazing these people are.
My lord, this I have filed. I am.
The miscellaneous application is misconceived. Full stop. The petitioner would be at liberty to pursue the remedies which are available in law. The miscellaneous is dismissed.
There is a connect.
28 also same.
28 also.
Which be is MA.
20.
There's nothing in this matter.
My lords, your lordships have consistently held that suspicion, my lords, however grave, cannot take.
No, but there's sufficient evidence here. Testimony of PW2, demand, PW3, 5,
My lords,
independent.
my lords, the complaint once, my lords.
Nothing in this.
My lords, he said that I asked him to come to my residence, but it is an admitted fact that when
Currency is found in your drawer. Charge, dismissed case.
20.
Item
My lords,
21.
I've already served, my lords, 1 year, 9 months.
That's all right. You have to serve out your sentence. Item 21.
May I please, my lords, I beg to appear for the petitioner state, my lords. So, lords, this is a matter of murder by beheading where the High Court has granted bail, my lords, only on the ground of incarceration of 650 days.
Yes. We'll issue notice returnable in the first week of July.
I'm deeply obliged.
22.
Up in July, Mr.
I'm on the cabinet. Okay. So, may I take seeking a parcel?
We'll take it up.
We'll take it up afterwards.
23.
23.
So in item 23, my lords, there is an application for bringing legal heirs of respondent number 1 pending, my lords.
Factual, isn't it? Family settlement has been accepted with the first appellate court
Who's appearing for
and
the
confirmed in the second
I
appellate.
am for respondent number 1.
What is the ground?
Plus the ground is, my lords, there are twofold, my lords. One is there was a constructive res judicata, my lords. The suit filed in 1998. My lords, it was barred by constructive res judicata because in 1981, my lords, a suit was filed by the respondent number 1, where he prayed that the father, the late father, should be debarred from, should be injuncted from alienating the property. My lords, the father.
But that suit was decided on merit, so what happened?
Yes, my lords, what happened was they failed to lead any evidence. The trial court notices that they have failed to lead evidence on any of the issues and takes up each and every issue and
That was
decides.
an issue relating to trial court's ex parte temporary injunction was involved. And this trial court dismissed for non-prosecution.
You can see it. Now, what about the substitution? Has notice been issued on the application for substitution?
I believe, my lord, In fact, we had filed an application of substitution as respondent.
So we'll allow the application for substitution.
It's been allowed.
All right, substitution ka application. All right, and then we can place it on a non-miscellaneous day.
Very good. May I pray for, my lord, any date?
Yes, you get it.
Yeah, yes.
24.
May I please your lordship? Cross,
matters against the same award.
How long will it take between the two of you in these matters?
I will take about 1 hour.
What about you?
I wonder whether he's saying this because we are at the end of vacation. No? I'll take about half an hour it will take me. But may I say one thing?
Either way, we'll list it now.
I understand. May I say one thing? In my laws, the appeal SLP against 37, your lordship had issued a notice. There is a question there of inconsistency. I don't want to trouble my lordship. Their 30 against their 37, which was decided on a separate day. The only question was valuation. So lordship may not keep it on board.
Anyway, we'll take it up on board and
Keep it on board. That's
Because my only respectful prayer is that my lords to issue notice in my matter also. It was a common award. Otherwise, it was next time.
but you are both here.
that's right. I
Serve a copy of Mr. Tripathi so that you know it's anyway the same award, same feelings, everything.
The issues are totally different.
Then lords ask for
We
time.
have made it clear that.
Because I am out of pocket.
Even at that stage, I asked for time.
Of course not. Of course not.
We'll list it in.
I will go on the record.
Day, in the third week of August for.
Mr. Tripathi, you are also on VC.
Oh, I'm so sorry. There's somebody ambitious in my chambers. My apologies. Actually, my lord, what had happened because of the Manipur matter, my lord, it was chock-a-block. So somebody would have just put in there in case I have to.
By way of abundant caution.
It's abundantly cautionable.
All right. But she's.
25.
Much.
25. 25, we'll just pass it over. We have one matter parted since yesterday. We'll finish that first. 26, we'll come back soon. Anyway, they wanted a.
Lord, 26 says end of the board, but I don't know what your lordship wishes to do.
I think 26, it's about these.
In fact, Lord, there is no urgency in this.
We'll keep it up to the vacation. It's not for a miscellaneous.
27.
27
also lordship before two judges.
27 before two judges later on. Yes.
Four matter.
29.
29. I'm sorry. Lord, we want to file some documents in this. We want to demonstrate. I'll tell you lordship what happened. I'll tell you lordship the point, and then I'll ask for the same. Lord, what has happened is this: that this is a contract, this is a PPA, which actually provides what will happen if there is a delay. Now, there are two parts to it. One is what is to be paid, and another part is that there will be extension of time. Now, my lord, merely because extension of time is to be granted because there is a force majeure event doesn't mean that the tariff conditions should also change. Because, my lord, there are two specific clauses which provide that they are being paid. Even when they are not supplying electricity, there is a provision for payment to them.
Original.
Lord, we want
That extension is all right, but it should not have a bearing on the tariff.
bearing on the tariff. That's what I'm saying.
Three sentences.
And it's difficult to accept.
I'm so sorry. I'm so sorry.
And my lord, because of that, my lord, and because I'm relying on clause.
Well, it's three sentences. I agree that if.
1 minute.
I'm so sorry.
Yes, my lord, because the impact of this, my lord, I will
Then
bring
no
out on
notice
that.
may be issued. If they want to file a documents, I can come.
Okay.
All right, just what do you have to say?
Well, just 30 seconds. 15-year contract. That 15-year gets deferred by 1 year, so the same 15-year block goes in. Tentatively, hypothetically, I should get 100 rupees in 15 years, paid to me over different rates in different years. Because the 15-year gets deferred, I get 100 rupees only in the next 15 years. I don't get 101. Now, the case that is being made out is, because your year 1 tariff was 1 rupee, but your year 2 tariff is 75 paise, I will not pay you the year 1 tariff. I will start from year 2.
Now, that is
what
where.
really happens then, my lords, is that the last year, the 15th year, I am tariffless.
Now, my lord, just see.
The contract.
Just see what will happen, my lord. 4.6.1.
It is really, my lords,
Nothing in the match.
I don't
No, my lord, see 4.6.1.
Will you just see page 189 for a minute? And he's already taken payment. Page 189, your lordship will see. Just see 189 clause, my lord, is 4.6.1.
I'm getting a payment at the lower
That says
rate.
that the tariff for the period prior to the date of commencement of supply. Page 189. Not digital, my lord. Physical page 189. Two in digital, I'm instructing. You see the heading itself, tariff for the period prior to the date of commencement of supply of power.
That's it.
The tariff for the period prior to the date of commencement of supply of power shall be the quoted.
Which clause?
461. 4.6.1.
Tariff.
But the heading is also important. The heading is tariff for the period prior to the date of commencement of supply. And the clause is that the tariff for the period prior to the date of commencement shall be quoted tariff for the first contract year with escalation for relevant period only for energy charge. He's paid. He's saying 100 rupees, he will not get 101. He has in fact collected payment, my lord, for the years before he started supplying of electricity.
What do you have to say to me?
Well, it's alternate supply. There is a commencement date and there is an expiry date. Now, there may be supplies prior to the commencement date in terms of infirm, etc. That's a separate bundle. There is no dispute on that. The dispute here, is from the commencement date for 15 years, I must be paid a tariff. My commencement date got deferred by 1 year because of force majeure which is admitted. Nobody is in appeal over it. Now that 1 year is deferred, my supply is for 15 years, I must get the rate I have quoted for that 15 years. That 15 years is given to me, Maharaj. The case made out is, in your quotation, you had different rates for different years.
That is prior to 1st of October.
I will knock out the first year.
Just
Then I will
not show the impact of this.
That changes the contract, Maharaj, on the route. It's a bidded.
Milord, he has taken, not because of supply, he has taken, my lord, there are invoices for this period.
Concurrently,
For the 3 years that he did not supply power, he has got payment. He has got payment at the same rate that he would have got it if he had supplied power.
Well, it's 4.7 of the contract covers exactly.
Well, otherwise, my lord, this clause goes. This goes.
Nothing.
My lord, I can understand, my lord, that if you don't give him the extension, then the extension clause.
Also, Mr. Gupta will not interfere. We've now made we've got the point, but nothing in this matter.
Item 30.
Great.
Just permit me, my lord, to show your lordship the invoices. What he has collected.
Great for me.
Item 30, issue notice.
31.
31.
Item.
The lot of stay may be granted in this matter.
Sorry,
Stay may lot from alienation of the properties of the director.
which matter?
30 million. Item.
No, sir.
Section 95.
No, 31, we are said to be issuing notice, yes.
31.
31.
Grateful.
Item 30, your lord, I'm so sorry, there was
Yeah, we-
item appearing in 30.
Yeah, we should notice and
And
connect.
we are requesting that similar interim order.
No, we have not passed interim orders now in any other matter, except some early orders which were passed. We are just tagging it with the other matters.
In fact,
We'll now
may I just
start.
bring one note fact, just today, in court 5, there were two guarantors, husband and wife. The husband's petition got listed in court 5 and the wife's petition has got listed before your lordship. That was item 8. We've just been able to secure one similar interim order which was.
So we have consistently not
have
passed
not
interim
granted
orders
any
in
of
these
those.
section 95 matters.
There are some orders.
We'll bring it
No,
here.
no,
No,
at
no,
the
not
earliest
at all.
point
At
of
the earliest
time,
point, some other bench had passed. We are not doing it. We'll
Your
resolve.
lordships have not passed.
We'll resolve the issue.
Yes,
We'll bring those matters here and resolve them when it comes up for final hearing.
that comes up on the 18th of July, so that
All right.
those may be checked.
Item 31.
Obliged.
Kerala story matter.
Yeah. Item 31. Item 31, there was another Kerala story.
25,
matter,
which is item
25. Passed.
That was directed to be tagged along with this.
Yes.
32.
My lords, I'm speaking out, but they are making a very
Yeah.
request.
Yes.
Relating to items 25 and 31. There's some significant new jurisprudence that reverses.
Kerala story.
That's.
Yeah, let the matter be called out. We are waiting
I'm
for it.
not a party, lordship.
That's all right. Matters is not being called out. When it is called out, you can mention it.
I was wanting to submit,
After it is called out, it's not that matter. Yes. Item
32.
It was the Hindenburg Adani matter.
Yes.
Now, they have filed a rejoinder to our reply. So only we want to say that they are making the investigation complex.
Yes.
So your lordship said last time that
there was a report submitted by the
The committee has submitted its report.
which is in a sealed cover.
It's a tentative report. And now SEBI has asked for an extension of time to complete their investigation.
Yes, I have pointed out, we have pointed out in a response that we have filed to the SEBI application that SEBI has been investigating Adani for many years, not just in respect of one particular investigation of 2016, but also in 2021 in response to a question and answer in Parliament. The minister stated that yes, SEBI has been investigating these Adani companies, etc. Now the point is, my lord, unless SEBI puts down on record as to what has happened to all those investigations which it had been undertaking. Just see this question answer in Parliament. Just give 3 questions.
What they are now saying is that they are completing the investigation, but they have to ask for 6 months. We may or may not grant 6 months.
No, it's not a question of granting 6 months or what I am saying is, my lord, they have to put on record as to what has happened to these investigations which they have been doing since at least 2016 and 2021, etc. They have to put this on record. What has happened to those? Because otherwise, Lord, what will be happening is that there is clearly, one can see that so clearly, somehow an attempt to shield the Adani companies in recent years. Prior to that, there are any number of orders of SEBI as well as the Securities Appellate Tribunal freezing Adani's trading on the stock market 2006, 2007, 2008, etc. But in recent years, despite many complaints having been made to SEBI over the last 6, 7, 8 years, etc., it appears that they are doing absolutely nothing despite it being written on the wall. If Adani company's shares increase abnormally by 10,000%, 5,000%, etc. over a period of less than a year, then obviously, my lord, alarm bells have to be rung. You can't say, and formal complaints have been made. They have stated in Parliament that they were investigating these Adani companies in that answer in 2021. They have said so. So therefore, the question is, what has happened to all these investigations? They must put everything on record before this court. Otherwise, my lord, what?
I'm one of the petitioner. That is 57/2023. Lordship, see here just 2 pages short argument I have placed.
Just tell us orally.
Lordship, 2 things are there. In this one, SEBI is very well equipped. And they are having their statutory duty under section 11(2)(e).
All right.
It says.
What is the next point? We got your point on the first.
This is one, they are having their statutory duty under SEBI Act. Under the provisions of.
Got the point. What's the next point?
Yes, Lordship. Second point is this. Apart from this, they are having legally also they are equipped to call for the information. One is this, they are member of EOSCO. Apart from this, see, even there is a provision under PMLA Act, that is Rule 93F, which does not provide any exemption to any foreign company to give any information to PMLA, ED or SEBI. They can collect all the information. Apart from there, they are supported by, we have premier investigate agency, like ED is there, CBI is there, IT is there. So all these, they can support it and they can very well collect in few months.
All right.
And already investigations is going.
Got your point.
2016.
Yes. I'm only for the extension for time and I'm opposing that under 11C, section 11C of the SEBI Act, they have not even apprised the court that whom they have appointed for the investigation. Because whenever it believes that there are some kind of manipulation, it has to carry out an investigation and whom they have appointed. Plus, in the application, they have only saying on the technical points that there might be some possible manipulations of the accounts. There might be some possible manipulation in the share price. So upon these imaginative grounds, extension of time cannot be sought. And my lord, one important thing, in their para 17, they are saying that actually time is needed of 15 months, but we will do in 6 months. So if they can do in 6 months, that complete in within a period of 1 month.
This one. I'll confine. Just see that question answer in Parliament, which I just handed over. B and E. Second page of this. This is a Answer on 19 July 21, more than a year and a half ago. B, yes, ma'am. SEBI is investigating some Adani Group companies with regard to compliance with SEBI regulations. Further, the Directorate of Revenue Intelligence, etc. Then, my Lord E, in the matter pertaining to issuance of global depository receipt by certain Indian listed companies, SEBI-wide order dated June 2016 had directed depositories to freeze particular beneficiary accounts of certain FPIs, including Abula, Cresta, APMS investment, etc. Now, these are the precise companies which Hindenburg in its report points out had invested more than 95% of their funds in Adani companies, these three funds. Therefore,
what is the reading from, Lord? I don't.
What has happened? How is it that SEBI missed out the fact that these three investment funds had been investing all their money in Adani companies? How is it that Adani companies did not come to be investigated?
Yes, Mr.
Yes, I'll confine myself to the facts, my Lord. I can't go here and there being a regulator. But the SEBI has our wherewithal and we are working on it. So far as, my Lord, the confusion has been created because of this. You pick up something in 2016, something in 2020 and connect it with the present issue which is arising from the Hindenburg report. What has happened is, my Lord, I'll file this by way of an affidavit. Right now, my Lord, kindly ignore the title, my Lord, which is note for, since my learned friend has raised it, I wanted to, my Lord, just clear the air. But 2016 is something totally different, distinct, and completely, my Lord, separate. My learned friend now wants that whatever investigations or proceedings were taken against a particular company, till now should be placed on record. I don't think that's the remit, but I have no difficulty. SEBI has made various submissions to the Your Lordships can skip that, my Lord. SEBI continues to reaffirm. Lord, can we come to page 2? The Honorable Minister of State for Finance, in his reply to the Parliament on July 19, had confirmed that SEBI is investigating some companies with regard to compliance with SEBI regulations. It may be noted that investigation referred to was in respect of possible non-compliance with minimum public shareholding norms and consequential violations. This investigation had commenced in October 20. It is hereby confirmed that the investigation referred to by the Honorable Minister had not commenced in 2016. SEBI has made a statement to the Honorable Supreme Court that it is examining, investigating the allegations made in the Hindenburg report. One of these allegations was related to non-compliance with MPS norms. SEBI has also submitted to the Honorable Supreme Court that current status of this investigation has been submitted to the expert committee constituted by the court. SEBI has also submitted to the Honorable Court that in the context of investigation into MPS norms, SEBI has already approached 11 overseas regulators under multilateral memorandum of understanding with International Organization of Securities Commission. Various requests for information were made to these regulators. The first request to overseas regulator was made as early as on October 6, 2020. It is this investigation that has commenced in October 20 that was referred to by the Honorable Minister of State for Finance in his reply. Now 16, please see, completely different. In 2016, in 2016, SEBI passed an order pertaining to issuance of global depository receipts by 51 Indian listed companies. No listed company of this group was part of the aforesaid list of 51 companies, which has been specifically stated in the rejoinder dated May 15, 2013 to this Honorable Court. However, there were some FPIs, including Cresta Fund Limited, Albula Fund Limited, and APMS Fund Limited, the GDR relevant accounts of which were frozen. As a consequence of 2016 order, it is hereby clarified that this action was purely a consequence of GDR matter and not related to any examination into so-and-so company. Though the orders were passed, they were challenged by whoever was aggrieved and came here and confirmed. The learned friend wants a roving inquiry that whatever happened, against this company since 16 or maybe 2008-9 should be placed. If your lordship wants, I can't have any objection, but that's not the remit of the petition. Remit is, my lord, the allegation, the Hindenburg report, which is going on. And, my lord, 6 months is the compressed time.
My lord, prima facie, they have dropped a finding against that.
Mr. Bhushan, only a minute. Lord, I will place this by way of an affidavit within 1 hour. This is, Lord, I didn't, Lord, expect that social media will become a subject matter of, Lord, argument before your lordship. Therefore, apprehending that it would, I have kept this as my note, but I will file it verbatim by way of an affidavit of an officer.
They have already filed one affidavit. They have already filed an
They have formed an opinion that we have
Please say
found.
this, just take it down.
And that
One
report,
second, just 1 second.
that
Please,
report
1
of that
second.
committee, which has been
1 second, yes. The expert committee has submitted a report bearing in mind the timeline of 2 months stipulated in the order of this court, in the order constituting the committee. Full stop. In order to enable the court and council to analyze the report and reflect on the suggestions which have been made by the expert committee, the proceedings shall be listed after the summer recess on 11 July 2023. Full stop. Next, the expert committee is requested to continue to assist the court. Full stop. The committee may hold further deliberations in the meantime. Full stop. The committee would be requested to take up any further aspects or suggestions as may be formulated by the court following the course of deliberations when the proceedings are next listed for hearing. Full stop. Copies of the report shall be made available to the copies of the report of the expert committee shall be made available to parties and their counsel to enable them to assist the court in the course of further deliberations. Full stop. The registry shall take steps accordingly. Next, SEBI is granted an extension of time till 14 August 2023 to submit its report.
Your Lordship may say that they must place the results of the investigations which they have admittedly been doing into Adani companies.
My lord, prima facie, they
Therefore,
have found.
at least they must place that on record as to what has happened to all these investigations which they said, which the solicitor has also.
We are dealing right now with the fallout of the Hindenburg report.
Yes, yes.
The purpose of these proceedings is not for us or for any public interest petitioner to conduct a roving inquiry.
No, no, it's not roving. I'm saying it directly related to the Hindenburg.
So whatever is directly related to the Hindenburg report,
yes,
which now the Solicitor General has said, he's also filing an affidavit immediately, he said, that one of the aspects which will have a bearing on what is disclosed in the Hindenburg report is the compliance with the MPS norm, the minimum public shareholding norm.
Yes.
He has also said that the 2016 investigation,
yes,
the 2020 investigation relates to the global depository risk.
No. They're saying that 16 relates.
16 relates to the global depository risk.
2020 is relating to.
2020 relates to the MPS norm, which has also some bearing on the Hindenburg report.
Yes,
Let
they
them-
must, they must place on.
What we have directed, they will be placing that on the record. We've directed
Prima
them to
facie, they have said they have
Your
found some
Lordship has
defaults.
just given them some time.
Yeah.
What I am requesting is, your Lordship may specify that they must place on record the progress made in this particular investigation, which is directly related to Hindenburg. The other aspect also of 2016, that GDR.
SEBI
So,
has placed on the record.
Because Hindenburg.
For your Lordship to consider whether, my Lord, ideally, it is the expert committee which would supervise and monitor the investigation. Your Lordships can, Lord, would your Lordships consider everyone to monitor the investigation? That's at this stage. But I leave it to your Lordship.
Mr. Solicitor, but you will place on the record before this court.
Of course,
an updated status
that's
report on
not
the
good.
investigation.
That's, I can't have any of that.
Both the
SEBI has placed on the record an updated status report in regard to the course of the investigation.
Lord, only Lord, request is, I am reiterating, Lord, the period of 6 months was compressed by us, Lord, taking realistic view of the matter. Your Lordships may consider it, Lord, may reconsider the August deadline.
My Lord,
let it, Lord, some reason.
Solicitor, tell us what you have done. Tell us what you have done, because we've already granted you 2 months. We have granted you now further extension of 3 months, which makes it 5 months. So effectively, you are asking for 6 months. We have granted you already 5 months.
The request was from.
We are not granting you an indefinite extension of time. If there is some genuine difficulty, you let us know.
My Lord, can it be, my Lord, end of September? Can it be in the end of September?
But I don't think that investigations they have done so far.
That
And
they
have
said,
it in
they have
July.
already said.
Solicitor, we have two options. We could have given you time right now until the 30th of September. Alternately, you tell us on affidavit, say by the 15th of August, what is the position? Then we consider if you are at the final stage of the investigation.
Please.
We will then see what steps.
If needed, my Lord, we can, my Lord, again urge your Lordships for further action.
We have not specifically dealt with each individual issue, but we have said that you will give us an updated status report on the course of the investigation, which will also cover the issue which has been raised by Mr. Bhushan.
Only your Lordships may add last line, liberty to file affidavit, my Lord, today, in terms of this. What I read, it was my note, my Lord, it can be mine.
we joined up, they have filed. My Lord.
Some 22-year-old assistant manager filed an affidavit on behalf of SEBI saying.
No, it's not 20. But it's 25, but that's a childish an argument to make that it's because he's 22-year-old.
That he denies all correctness of all other submissions.
But I do file an affidavit in terms of.
Yes, my Lord, of a person authorized.
And give a copy.
He's an officer, my Lord, and.
My Lord, they may submit some finding up to today, what finding they have drawn, and they shall bring something.
How can we ask them to, when the investigation.
Time of facie, they have said that they have found.
When the investigation is on, can we tell them to tell us what is the prima facie finding up to today?
They have said in their application.
Take it, sorry.
My Lord, in my petition, in prayer B, I have asked for investigating role of LIC and SBI because huge amount, almost more than 40 crore has been put to Adani companies. So that also it can be taken into the terms of committee, Lordship. The expert committee.
That is
very important.
Report.
Yeah,
will be.
But this is not there in the terms of committee, Lordship. It can be included.
You don't want to just because some public interest petitioner says investigate the role of LIC. Look, these are matters. We have asked SEBI as a statutory regulator to apprise us on what is the course of the investigation. Let us first understand from SEBI what the position is after they submit a report to us. Thereafter, we'll go next step if it becomes necessary.
Lordship, they have been made parties in my petition and nobody has, they have not served any, they have not filed any reply.
But unless we ask them to, they're not bound to file something here.
Notice was issued, Lordship, in that.
All right, we'll see.
If they can take out all these things in that. Item 34, Lordship.
There are five of affidavit. Is some affidavit. And para 5. The affidavit? Yes. Okay. Counter.
Yeah, WhatsApp.
Seven pages, right?
Yes.
You got? Yeah. Which para?
Para 5 or space 3.
Send it to me again.
I sent it. One minute.
At the governance. So PDF page is 5.
What?
Yes. Yes.
Accept.
It says, my lords, it is submitted that the governance of municipalities.
Just once again.
Sorry.
Mr. Jain, go ahead.
Yes.
My lords. It is submitted that the governance of municipalities, independent of the regime of the governance of the elected state governments, in the context of Delhi, it is pertinent to note that on 1st February 1992, Article 239AA, 69th Amendment, came to be inserted in the Constitution of India, and with effect from the same date, the GNCTD Act 1991 also came to be notified, which collectively contain a mechanism for the governance of model of Delhi. Thereafter, by virtue of the 74th Amendment to the Constitution, Part 9A was added to the Constitution with effect from 1st June 93, providing for the municipalities. Article 243PE defines municipality as an institution of self-government constituted under Article 243Q. Article 243ZB made a provision for application of Part 9A to the Union territories. The para 6 Yes. As a matter of fact, the statement of objects and reasons for the insertion of Part 9A in the Constitution clearly notes that the urban local Hello.
C3A and C3.
Alert may see para 6.
Yes.
That is a matter of fact, the statement of objects and deeds for the insertion of Part 9A in the Constitution clearly notes that the urban local bodies were not able to perform effectively as vibrant democratic units of self-government and were turning out to be weak and ineffective for various reasons, including the failure to hold regular elections and inadequate evolution of powers and functions. So I am pausing here for a minute, Lordships. Lordships will recall that Lords, the 73rd and 74th Amendment, Lords, were sought to be brought almost one after another. 73rd Amendment deals with Panchayat, 74th Amendment deals with Lords, municipalities, which include urban local bodies like the municipalities which are in big cities. Now, my lord, there was a need felt, as it was felt, my lord, in the case of the governance of Delhi, that the will of the people, my lords, ought to be articulated, and there should be a robust mechanism for democratic participation.
So basically, your contention is that MCD is an institution of local governance under Part 9 of the Constitution. And the role of the administrator in relation to MCD as a institution of self-governance is distinct from the role of the governor of the administrator under Article 239AA when he provides aid, when he acts on the aid and advice of the Council of Ministers.
That is the nucleus.
After
That's the argument.
after the amendment to Part 9A, were amendments carried out to the Delhi Municipal Corporation Act? Second question, following that, when amendments were carried out, does the amendment draw out a distinction between the roles to be performed by the administrator, by GNCT, as well as the Union of India?
Yes,
Here, does the statute talk about the different roles to be performed and specifically attribute any particular performance, and more particularly with respect to alderman? Of course, it says the section 3.3 says Lieutenant Governor.
Yes.
But other provisions which talk about GNCT power or the government of Delhi as against to draw out a distinction that exists is what you will have to tell us.
Absolutely. Annexure in my
Annexure?
Annexure. Ask me. R1 and R2.
You want to see us now or you want
Lords,
to
the seat right now, sir. Page 23.
Okay.
Sorry. R1 is at page number page number 13. Before this, my lords, I mean, just before I read this annexure, my lords, I may point out that MCDA, which is my lord Delhi Municipal Corporation Act, actually, my lords, envisages 5 different sources of exercise of power. One is the central government. Other is, my lord, the government, that is GNCT. Government has been defined as GNCT. Central government, without being defined, is used at several places. Third is the administrator, which is a distinct expression used here. And fourth, my lord, is the corporation itself, which is a elected body. Corporation is defined. And then, my lord's commissioner, who is also defined.
So there are some powers which are not entrusted to the commissioner, and there are some powers which are entrusted to the corporation as distinct from our administrator or the state government. So in that view, my lords, if your lordship also sees, is government. 21A is the government, which was added for the
And administrator is one. Administrator is one, it's clear. Then there's no definition of GNCTD.
No, my lord, there is no definition of GNCTD, but that is, my lords, coming in 21A. The government is coming.
Correct. You are
Your lordship sees 21A, which was brought in, my lords, by the 1993 amendment. The definition is government means the government of GNCTD. So it is brought after, because by that time 69th amendment had come, and my lord, by that time GNCTD had come, and by this time, my lord, even the 74th amendment had come. And my lords, now the three definitions were added, my lords. One is that of, my lords, the administrator, which was not there earlier. Prior to 1st June 1993, there was no definition of administrator. So, my lord, it has been, administrator has been brought as an independent authority apart from the four authorities which existed earlier. In fact, three authorities which existed earlier. The three authorities which existed earlier were the government, which was a parliamentary act, and Delhi was not totally a union territory, so the central government, and then the corporation and the commissioner. Now, two more layers of authorities were added, that is the government being defined as GNCTD and administrator. And all have different roles. If your lordship sees, for instance, my lord, the GNCTD's role, if your lordship sees in this chart, 92A, recruitment to the category B and category C posts. Now, this is, my lord, totally, my lord, a task which has been entrusted to GNCTD.
Okay, you categorized the central government, government of GNCTD, administrator, corporation, and commissioner.
Yes.
We are basically concerned about 2 and 3.
And my lords, it is very clear, my lords, that say for instance, the lordship sees section 3. Within section 3, there are different roles defined. For establishment of the corporation, there is a role for central government. For my lords, within the establishment of corporation, so far as the aldermen are concerned, my lords, there is a role of the administrator.
Nominations by the state government under section 3.3?
No, my lords, there is not.
3.3B1 is by administrator.
That's right.
So to draw the contrast.
In fact, my lords, the scheme of the act is that the central government's tasks can be delegated, the tasks of state government can be delegated. You not
The commissioner can be delegated, not yes. You said that.
Yes. 490A, 490 capital A, please. 490 capital A, 490 capital B, and 491. I have not.
You've said that.
There are 16 of my affidavit.
Right.
If your lordship sees, my lord, I have given the.
But no delegations contemplated of the powers of the administrator.
Yes.
So really speaking, what your pretension is twofold. As I said, that the municipal corporation, MCD, is a body for local self-governance, which, though governed by the Act, namely the DMC Act, is ultimately governed by Part 9A of the Constitution. Now, the administrator is a term which is expressly defined by the DMC Act. The same act has defines the state, the central government, the state government, the central government, the commissioners, and the administrator. So, yes, corporation. So when the power is conferred on the administrator, it can't be read to mean the power of has been conferred on the state government, because where the statute wanted to use the expression state government, it has used the expression.
Because both definitions were brought together, and if there was any element of aid and advice contemplated here, the legislature would have clarified it. And in any case, my lords, it is a governance model completely independent of the state government.
Your amendment of 1st October 93 brings about both the definitions of an administrator and
both the definitions.
And 93 is followed by the previous year 239 AA comes into force in the past.
So that is because
that's a different realm is your argument.
Because even prior to when the GLCTD Act was brought in 239, the belay were brought by 69 amendment. The post state reorganization, we used to have a chief minister in it. After that, the chief minister model went and we had a metropolitan council and MCD. The elections were used to be held for MCD and virtually all the municipal functions as a local body. The municipal corporation of Delhi was handling even at that point in time electricity and water. They were also part of MCD. It was later on only.
So the sum and substance is that section 33B1.
Yes, sir.
Providing nomination by an administrator is by administrator in his capacity.
In individual capacity.
In his individual.
Not as.
Let's hear Dr. Singh. 3 minutes. Got your point. Your submissions have been summarized in this counter actually.
Yes. In fact,
3 minutes.
Now, yes. Pointed. The Lordship sees, Dr. Singh, I just complete with the Lordship's permission. If your Lordship sees few more paragraphs which I just wanted to point out, is paragraph number 13
of your notes.
Yeah, before the Lordship sees paragraph number 11. Here, my lords, I have given my lords how, my lords, it is a mirror image. The amendments are meant to, my lords, articulate
part 9A.
Yes, given to part 9A.
Okay, we saw carried out.
So this is, my lords, all these I have given a comparison.
And then annexure R1 we have seen.
Yes, and R1 and R2, my lords, specifies clearly the powers which have been vested with the administrator, as distinct from anybody else. So not only section 3, subsection 3B1 power was given to the administrator.
There are various other powers.
Yes, certain other powers were also given to the administrator.
All right, let's hear Dr. Singh.
And they are all, my lords, non-delegable.
All right.
Contra distinguished to 490A, 490B.
Which are delegable powers.
Which are delegable powers.
Yes, Dr.
4 minutes. Number one, the query asked by Justice Narasimha. No separate power to state government to nominate.
No power to state
Not the query. Is there a separate power, statutory provision, rule, regulation, which gives a quota or a system for the state government to nominate in parallel or separate from this one? Answer no. Number two, please turn to my second volume additional documents, which is the IA Malus 59804. It's very interesting. 59804. Page 7 and 9 show Malus 2017, which is the same practice for 30 to 35 years. It's an example.
That's practice.
2017 and continuously, always 2017, page 7 and 9 show that the Malus recommendation is made.
Doctor, how long will you take?
3-4 minutes. 3 or 4.
All right, then we'll wrap it up at lunch.
Yes. So, Malus, page 7 and 9 show the practice for 30 years. This is only an example. Never has it been that the LG appoints in his own name. Number 2. Number 3. Well, let's just consider what havoc your Lordship is being asked to play with the concept from Shamsher Singh onwards. Every authority, unless there is a special...
Contention really is that the doctrine in Shamsher Singh applies when there is an executive power which is being exercised. Now, the executive power,
much beyond Shamsher.
The governor or the president would exercise They're passed on the aid and advice of the council.
There's another angle.
Yeah.
Sorry.
Here, it's completely different because it's a local self body, according to them.
That's all the more. Local self body, that's para 6 of his counter relying upon.
Democratic angle arising out of our latest judgment, where the executive power is always vested, when you are seeing in the constitutional perspective. But when an act is made, and the act specifically provides that the power is to be vested with the lieutenant governor, administrator, so to say, then recalling the earlier principle that it will always be exercised.
Let me answer that.
Yeah.
Two things.
These are only doubts tentatively.
No, your lordship's queries are very useful. Let me answer. Samsher Singh, I cited only the starting point. Your lordship has carried the Samsher Singh principle through 2 constitution benches for this Delhi. On interpretation of Act, same Act. On interpretation of the same municipal Part 9A, 9B, which are there for 30 years. All nominations, take for example our upper house. The nominations are always by the president, but always on the aid and advice of central government. Now, para 6 of my learned friend, just note the para, I'm saving time, I'm not showing, of my learned friend's counter, says it is a democratic impulse of democratic local self-government. Part 9A is describing. That is exactly what I'm saying. The democratic impulse of democratic local self-government is not to be nullified by the central nominee deciding. Part 9A is supposed to decentralize. It's the opposite of what it's saying. Part 9A is the decentralized, it's not the reverse.
We close orders then.
Just one. Very 9A is the opposite of what he's saying is decentralization. Now, that I is to be seen for the reason. Your lordship would query if you have a separate state government and administrative mention, then it means separate. Now, the answer is this. Page 7, 9 of that show that where state government is mentioned, it means it doesn't even go to the LG. The department ministry stops there. Where the LG is mentioned, it goes, the file goes to the LG. But in both cases, on the aid and advice of the ministry. Well, the difference between this is the query which you are supposed to be troubled with. That's the query.
Can you just repeat that?
That's why I must deal with it in 30
This
seconds.
last point, can you just repeat?
Yes, that's the query. My learned friend argues that one is the state government used, sometimes the administrator used. When it's the administrator used, it means the administrator must act personally. In actual fact, that IA number 59804 at page 7 and 9 demonstrates what is happening for 30 years. Where the state government is mentioned, the file stops at the department. Where the LG is mentioned, the file goes with the aid and advice to the LG. In both cases, it has no difference to the aid and advice concept. LG is bound. It is the traveling of the file. That's all. That's the papers, 7, 9 of that file. So your lordship is being really asked to change the entire concept of aid and advice. Kindly see, Manoj, if your lordship were to hold in this case, on a mere showing the word administrator.
But there will be provisions where administrator means administrator EO nominee. For instance, an appellate authority.
Absolutely. We concede. Revision, suo motu revision, clemency power, remission power. Absolutely right. Where by the very nature of the power, he has to act personally. Your Lordship knows that sometimes the governor removal of a chief minister. Can the chief minister give aid and advice?
But the drawing of the distribution of, we'll have to see that because we have not placed. Both of them are 1993 amendments.
Yes.
Both the administrator as well as the GNCTD.
Yes.
And also bifurcation of that powers.
But from then onwards.
1993 amendment, if we have a look, perhaps we will be able to know why, for what reasons.
We can collect the SOR and give it to you.
Will indicate for what.
We can collect the SOR and the material, we'll file it here.
We'll file it.
We'll consider it, we'll close.
May I have my lord's leave to mention item 25.
22 before 35.
Yes, Mr. Sarve?
My lord, today afternoon there is some problem. Could we have 25 tomorrow, my lord?
That is the Kerala story.
Yes.
I'm in that.
You can take it tomorrow.
Same for 22. Your Lordship said, Passover. We thought 22 is, I'm called by the NIA in a jurisdiction-less matter. The police is investigating in West Bengal.
Anyway, 25 for tomorrow, my lord.
Tomorrow, they'll take 5 minutes only.
21 also, your lordship will be hearing.
All right,
22 and 25.
So Patwalia, 22 will keep tomorrow.
31
25 the Kerala story, all the matters we'll keep tomorrow. Just like all the matters together, all right?
Continue this.
item
34.
No, we are reserving orders now.
All right, my lords. I needed some about few minutes, my lords.
Yes, sure, tell us. No, absolutely, because that, certainly.
All other matters can.
All the matters.
Tomorrow.
Yes, of course. 31 as well, then 25 will come. Kerala story, I don't want to call out numbers for Kerala story. All Kerala story matters will be tomorrow.
That is 25, 31.
Yes, 25.
22 is tomorrow.
25 and 31.
Those other matters are all over, and except Mr. Patel. 22 is also tomorrow. 22 is tomorrow.
No, the item 26 was
Mr. Jain?
notified at the end of the list. The Kerala was the temple elephant, the captive elephant. Two IAs, your lordship specially noted.
That will
Puram is going on just now.
That will keep it after the vacation.
But then kindly keep it tomorrow. No, the Puram is going on. And this is the time when, in the teeth of the lordship's orders of 2015, they are being treated with such abject cruelty.
Yes. All right. Now tell us.
Your lordship could keep.
Yes, please.
I just could respond to the secretary's questions. First of all, my lord, the practice being followed for 30 years would not really be material. Because, my lords, if my lords on the wrong side of the constitution or the statute, if any practice has been followed, that would not really, my lords, make a difference because the lordships have seen. Even in the CV matter, my lords, they were both the matters, my lord, there were certain interpretations.
But that is also, therefore, a realistic appraisal by the LG of what the position should be, because that's also a post-amendment practice. It's a post-90.
All LGs were wrong. All LGs were wrong.
What do you say about the other argument which he has made?
I am on, my lord, the practice, my lord, which is after the lordship's judgment in CB1, first CB of 2018 and second CB of a few days back. My lords, in both these judgments, my lords, what your lordships have interpreted is in detail with regard to, my lords, the aspect of aid and advice in the context of Delhi, despite being a union territory. And your lordships have read that so far as aid and advice is concerned, that is clearly distinguishable, and insofar as would not make any difference because of the will of the people. And your lordships have also given, my lords, part 14A to them on the principle that if part 14A is not expanded.
There's another way of looking at it. Is the nomination of people who have specialized knowledge
in local affairs,
in a local body,
Local affairs.
such great concern to the Union of India that the Union of India's representative should choose those?
After decentralizing. Not at all. After decentralizing.
Otherwise, what happens is that another very important thing, that Mr. Jain, by giving this power to the lieutenant governor, he can effectively destabilize the democratically elected municipal corporation. Because these people will sit in the standing committees, ward committees, the standing committees. By taking 10 people of his choice, he can effectively, they have the voting power there.
Let me clarify. If your lordship sees the provision, these gentlemen do not have any power to vote. They do not vote.
Corporation in the ward they have.
Sorry?
They have power to vote in the ward and therefore in the standing committee. In the ward committees, he has nominated all 10 for 2 ward committees. 2 ward. Those 2 wards deliberately where they are weak.
Yes.
Those 2 wards, he has nominated them. They will now go to the standing committee from those wards.
Structure of the standing. My lords,
They have a voting power. Of course they have a voting. Otherwise, why would you nominate them? In the ward level, they have a voting. There's no question of nomination.
let me clarify, my lords.
Lordship may reserve now.
Extra two in your.
Exactly.
Seen that.
Your lordship, my lords, this definitely DCB, there is a proviso.
I'll let you give another note. You give a note, small note of 2 pages, we'll consider it. Yes.
Grateful, very deeply obliged.
6 tomorrow.